Okay, so what I want to talk to you about in this section of the program is how are QME panels produced and how are AMEs selected. And basically what I want to review with you in this section are the labor codes that govern the QME panel process. And there's not a lot of them. And I want to review some of the subtle nuances of these labor codes so that you understand the general distinctions between how QME panels are generated in the case of a represented injured worker and how that process differs from the way panels are generated in relationship to an injured worker who is represented. So let's begin at the very beginning with a discussion of Labor Code 5402. Now, Labor Code 5402 is also known as the $10,000 rule, and this is one of the very strategic labor codes that comes into play immediately after an injured worker or an employee fills out a claim form claiming an industrial injury. So let's review 5402. Section B says, begins to establish the philosophy of this code. It says that if liability is not rejected within 90 days after the date the claim form is filed under Section 5401, the injury shall be presumed compensable under this division. So let's just take a break right there. Labor Code 5402 establishes a 90-day period during which the employer can investigate the facts surrounding the claim for industrial injury and can take their time in determining whether or not to accept or reject the claim as compensable. However, after the 90-day time limit has passed, the injury is de facto and by default considered to be compensable. It goes on to read that the presumption of this subdivision is rebuttable only by evidence discovered subsequent to the 90-day period. And that's an important distinction for this labor code because it disallows the rebutting by information that has been discovered after the prior to the 90-day time limitation. In other words, if the employer has knowledge of facts during the initial 90-day period, they can't then raise those facts after the 90-day termination date. Only new evidence discovered after the 90-day termination date is information and evidence that is applicable to the rebuttal process. And that makes sense because they could have used that information prior to the 90-day termination period. And then the next section, Labor Code 5402C says that within 1 working day after an employee files a claim under Section 5401, the employer shall authorize the provision of all treatment for the alleged injury and shall continue to provide the treatment until the day that liability for the claim is accepted or rejected. Until the date the claim is accepted or rejected, liability for medical treatment shall be limited to $10,000. And this is important to understand because many times we're going to be doing our QME evaluations due to claims that have been rejected. And the reason that the claim is rejected is not simply because the employer doesn't believe that there's been an industrial injury, but simply because the employer wants to stop the bleeding from the $10,000. Because Labor Code 5402 says that medical treatment must begin immediately or within 1 working day, and that treatment shall continue up until inclusive of $10,000 until the claim is either accepted or rejected. So if the employer has some concerns about the compensability of the injury, they don't need to wait the entire 90 days. They can immediately reject the claim and thereby stop the bleeding from the $10,000 of medical treatment which is provided for under Labor Code 5402C. So many times the QME examinations that we're requested to perform are simply to determine compensability because the claims administrator has rejected the claim either within the 90-day time period or even sooner prior to the expenditure of up to $10,000. So that's an important labor code to be aware of in those cases where your role as the qualified medical evaluator is to determine the compensability of the injury. Okay, the next labor code that I want to go over with you is Labor Code 4060. This governs comprehensive medical legal evaluations where the dispute arises regarding the compensability of the injury. And we just discussed some of the scenarios where compensability can be contested under Labor Codes 5402B and 5402C. So let's just read this code. 4060 Section A says that this section shall apply to disputes over the compensability of any injury. This section shall not apply where injury to any part or parts of the body is accepted as compensable by the employer. And so many of the qualified medical evaluations that you are going to get are what are referred to as 4060 evaluations. In other words, the role of the qualified medical evaluator is to determine whether or not there actually is an industrial injury for which the claims administrator or the employer is liable. In other words, the role of the qualified medical evaluator is to determine the compensability of the injury. Section D of this same code goes on to describe the process whereby the parties can request a qualified medical evaluator. So let's just read this code. It says that if a medical evaluation is required to determine compensability at any time after the claim form is filed and the employee is not represented by an attorney, the employer shall provide the employee with notice either that the employer requests a comprehensive medical evaluation to determine compensability, or that the employer has not accepted liability, and therefore the employee may request a comprehensive medical evaluation to determine compensability. Either party may request a comprehensive medical evaluation to determine compensability. And in those cases, the evaluation shall be obtained only by the procedure provided in Section 4062.1, which is the section that we refer to for the QME panel process related to unrepresented injured workers. So Labor Code Section 4060 has to deal with compensability issues. So when there's disputes over compensability, whether or not there actually was an industrial injury, either party, such as the claims administrator or the injured worker, can request a comprehensive medical evaluation, and those are what are referred to as 4060 evaluations. And I'm going to show you the QME panel request forms wherein either of the parties, either the claims administrator or the injured worker, check the appropriate box to indicate that the examination is indeed a 4060 evaluation. And that would be QME Form 105, and we'll go over those forms for both represented and unrepresented injured workers in just a moment. Now, continuing with Labor Code 4060, it says that for injured workers who are represented by an attorney, a medical evaluation to determine compensability shall be obtained only by the procedure provided in section 4062.2, and that would be QME Form 106. And we'll go over that form also in just a moment. Okay, so let's now get into the Labor Codes 4062.1 and .2, beginning with 4062.1 as relates to unrepresented injured workers. And it says that if an employee is not represented by an attorney, the employer shall not seek agreement with the employee on an agreed medical evaluator, nor shall an agreed medical evaluator prepare the formal medical evaluation on any issues in dispute. And that makes sense. When the employee is not represented by an attorney, the employee is basically at a disadvantage. And the claims administrator, being involved with administrating workers' compensation claims all day long, day after week after month after year, has much more experience with the workers' compensation process than does an injured worker. And so there is no opportunity for the parties to agree on an agreed medical evaluator in those cases where the injured worker is unrepresented. That would present an unfair advantage to the claims administrator and would unnecessarily disadvantage the injured worker. And so here's the process. Here's the process involved. And this is a key quotation and a key labor code that you should be familiar with. It says that if either party requests a medical evaluation, that's either party, meaning the claims administrator, the injured worker, or in the case of represented workers, which we'll talk about in just a minute, would be the injured worker's attorney. So it says that either party may submit the form, and we're talking about QME Form 106, the form that is prescribed by the administrative director requesting the medical director to assign a panel of 3 qualified medical evaluators in accordance with section 139.2. However, the employer may not submit the form unless the employee has not submitted the form within 10 days after the employer has furnished the form to the employee and requested the employee to submit the form. The parties submitting their request form shall designate the specialty of the physician that will be assigned to the panel. And this is an important code because it suggests and it indicates that the employee has the first opportunity to select the specialty of the qualified medical evaluator, because it's the employee that has the first opportunity to request a panel. Now, if the employee does not follow through with the dictates of the claims administrator and request the 3-member panel from the medical director, then the employer or the claims administrator, which are synonymous terms in this context, then assumes the right to request the QME panel. And in that circumstance, the claims administrator has the opportunity to request the specialty of the evaluator to produce the evaluation. And this will become important in those situations where there's a dispute over the specialty of evaluator. And this seems to be an increasingly common theme with regards to QME panels, is that there's a dispute amongst the parties as to the specialty that will prepare the evaluation. Well, it's important to know that initially anyway, within the first 10 days, it's the employee that has the opportunity and the right to select the specialty of evaluator to produce the evaluation, unless there's good cause showing later on, that the specialty is inappropriate for the case or the injury in question, that specialty is generally upheld by the administrative director in those cases where there is a dispute or a challenge as to the specialty of the provider to provide the evaluation. So it's important to notice and to remember these timelines and to remember when each party holds the right to request the panel, because it's the party that holds the right to request the panel that has the opportunity to select the specialty of the provider to produce the evaluation. So I just want to show you these forms, and these are available on the Division of Workers' Compensation website under their Forms heading. And what we have here, this is QME Form 105. So you'll notice that this is a request for QME panel under Labor Code Section 4062.1 for unrepresented injured workers. And notice here in this section that the party has the opportunity to check the appropriate box as to which labor code is going to be governing the medical evaluation in question. If it's a compensability examination, they would check the box here under 4060. If it's a non-medical treatment dispute under Labor Code Section 4062, which is the section that we're reviewing right now, that would include a checkbox right here. And if it's another evaluation under Labor Code Section 4061, which deals with disputes over permanent disability and permanent impairment, this would be the appropriate box to check here. Now, many times the examinee, the injured worker, does not know these codes, but certainly if the evaluation is being ordered by the claims administrator, one of these boxes would be checked. Okay, so this is QME Form 105 for unrepresented injured workers, and then let's go to QME Form 106 for represented injured workers. This is the request for QME panel under 4062.2, and we'll discuss this code in just a moment. But this is the code that relates to represented injured workers. So again, they have the opportunity to check the box as to which type of evaluation is being requested, whether it's under 4060, 4061 for permanent disability disputes, or other disputes under Labor Code Section 4062. Okay, now for represented injured workers, we refer to a different section in Labor Code 4062.2, and that's 4062.2. So this is the code that governs the comprehensive medical evaluation to resolve disputes over injuries on or after 1105 when the employee is represented by an attorney. Now, what we're going to see is that 4062.2 describes a process much different from the process described by Labor Code 4062.1, because when the examinee is represented by an attorney, we have more parties and more potential for dispute as to the type of evaluator to be assigned to the qualified medical evaluation panel. So 4062 adjusts and accommodates and handles those sources of potential disputes. So let's go through the subsequent sections of this code. So Section B says that either party, so that is either the claims administrator or the attorney of the injured worker, either party may request the assignment of a 3-member panel of qualified medical evaluators to conduct a comprehensive medical evaluation. The party submitting the request shall designate the specialty of the medical evaluator, shall also designate the specialty of the medical evaluator requested by the other party, if it has been made known to the party submitting the request, and also shall designate the specialty of the primary treating physician. The party submitting the request form shall serve a copy of the request form on the other party. So you can see here where there can be competing designations of the specialty of the medical evaluator. Whereas one party submits a request for a 3-member panel requesting, for example, a chiropractic panel, and the other party submits a application for a 3-doctor panel for perhaps an orthopedic specialty. And it's these situations and circumstances where we can get competing specialties. And these disputes over the specialty of the medical evaluator many times have to be resolved either among the parties or by the administrative director. Well, within 10 days of assignment of the panel, once the panel actually does get assigned, each party may strike one name from the panel. So imagine this, a 3-member panel finally has been agreed upon. The specialty has been agreed upon, and a 3-member panel has been issued by the administrative director. Well, within 10 days after the issuance of that panel, each party may strike one name from the panel. So the attorney for the injured worker strikes one name, the claims administrator strikes one name, and we're left with one name, one doctor on the QME panel. Well, the remaining qualified medical evaluator shall serve as the medical evaluator. This is known as the last man standing. And the last man standing is referred to as the panel QME. The panel QME, the last man standing, becomes the panel QME. And I reiterate that 3 times because it seems there's some confusion as to the designation of panel QME. And I'll elaborate on that a little bit more in just a moment. Now, if a party fails to exercise the right to strike a name from the panel within 10 days of assignment of the panel by the administrative director, the other party may select any physician who remains on the panel to serve as the medical evaluator. So, for example, if the applicant attorney strikes one name from the panel and then does not receive notice from the claims administrator of the striking of another name from the panel, then the applicant attorney has the opportunity to choose from among the 2 remaining doctors on the panel. So there is an advantage to the applicant attorney in this sense if the claims administrator does not exercise their right and option to strike one name from the panel. Now, it's interesting because there seems to be some confusion now as to the designation of AME, QME, and a former designation that used to be operative known as the Agreed Panel Qualified Medical Evaluator. And I think I'll hold off on just a minute to discuss that. And so I just want you to put that in the back recesses of your memory that in a moment we're going to clarify the designations between AME, QME, and Agreed Panel QME. Okay, so let's start to introduce the topic here of the Agreed Medical Evaluator. Labor Code Section 4062.2F says that the parties may agree to an agreed medical evaluator at any time, even after the issuance of the 3-member panel, except as to issues subject to the independent medical review process established pursuant to Section 4610.5. And 4610.5 has to deal with disputes over medical treatment. So qualified medical evaluators and agreed medical evaluators no longer resolve disputes over medical treatment. Medical treatment disputes are now handled under independent medical review. So except for disputes over medical treatment, the parties can agree to an AME at any time. So if an agreed medical evaluator has been assigned, then a panel shall not be requested pursuant to subdivision B, and we just reviewed subdivision B, on any issue that has been agreed to be submitted to or has been submitted to an agreed medical evaluator unless the agreement has been canceled by mutual written consent. So let's review this. The parties can agree to an agreed medical evaluator at any time, and the agreed medical evaluator does not need to be a qualified medical evaluator. So at any time, the parties can call each other up and say, hey, with regards to issue A, notwithstanding all the other issues, but just with regards to issue A, such as perhaps the permanent impairment, such as perhaps the causation of the permanent impairment, how do you feel about having that issue resolved by Dr. Smith? And the other party could say, Dr. Smith, yeah, I don't have any objection to that. Let's have Dr. Smith. Let's agree that Dr. Smith will handle issue A, or all the issues, that is. Could be any or all of the issues. And any or all of the remaining issues can be handled by the qualified medical evaluator. So the parties can agree to an AME at any time. And this represents a change in the recent law under Senate Bill 863, whereas before the parties had to be able to demonstrate that indeed they tried to agree on an agreed medical evaluator, but they were unable to agree. Now it's no longer required that the parties attempt to agree on an agreed medical evaluator. However, they do have the opportunity and they do have the option at any time to try to come together to agree upon an evaluator. But it's no longer required as it used to be, and I'll elaborate on that more in just a moment. Okay, and finally, the final labor code that we're going to be involved with regards to our QME panels is Labor Code 4061. And as I demonstrated to you on the QME Forms 105 and 106, Labor Code Section 4061 is the code that deals with disputes over permanent disability. So let's establish this scenario. You have an injured worker who's receiving treatment from the primary care physician, and the primary care physician determines that the injured worker is now permanent and stationary, and the primary treating physician issues an opinion on permanent impairment. Well, one or more of the parties could dispute that permanent disability rating or permanent impairment rating. You could have an injured worker who gets a permanent impairment rating of, say, for example, 0%. I'm just making this up as an example. Injured worker gets a rating of 0% issued by the primary treating physician, and the injured worker objects and disputes that and says, no, I'm having a lot of problems. I'm still suffering. This is not an accurate representation of my current condition, and the injured worker could declare a dispute over permanent disability. On the other hand, you could have the claims administrator declare a dispute over permanent disability. The claims administrator gets a report from the primary treating physician that describes all this high level of permanent impairment and all these restrictions to activities of daily living. And the claims administrator could say, hey, this sounds overstated. This does not sound accurate. This does not look to be substantial medical evidence. And the claims administrator could request a qualified medical evaluation under 4061 by declaring a dispute over the permanent disability. So let's read this code section. It says if either the employee or the employer objects to a medical determination made by the treating physician concerning the existence or extent of permanent impairment and limitations, or the need for future medical care, and the employee is not represented by an attorney, the employer shall immediately provide the employee with a form prescribed by the medical director with which to request assignment of a panel of 3 qualified medical evaluators. So again, in this situation, the injured worker, meaning the employee, has the first opportunity to request the panel or the specialty of panel, the specialty of evaluator to provide the comprehensive medical legal evaluation. So these codes provide some different distinctions for us and some different types of evaluations that we can expect to see as qualified medical evaluators. So we'll be seeing disputes over compensability. We'll be seeing disputes over a variety of non-medical treatment related issues. And finally, we'll be seeing disputes over the level and extent of permanent impairment or permanent disability. Finally, under section 4061.c, it says that either party may request a comprehensive medical evaluation to determine permanent disability or the need for future medical care, and the evaluation shall be obtained only by the procedure provided in section 4062.1, which is the section that we refer to and we rely on in those situations where the employee is unrepresented. So let's go over these designations then of QME, AME, or Agreed Panel QME. And I want to spend some time talking about the former designation of the Agreed Panel QME. As I said, the Agreed Panel QME no longer exists. And the reason it no longer exists has to do with changes in Labor Code Section 4062.2 as relates to represented injured workers. And this was a change in 2014 as a result of the passage of Senate Bill 863. Now, it used to be that the parties, in a case of represented injured worker, the parties had to demonstrate to the administrative director that they attempted to agree on a medical evaluator to provide the evaluation. In other words, they had to try to come together to select an agreed medical evaluator. If they were unable to agree on an agreed medical evaluator, then and only then would the administrative director in Oakland issue a QME panel. Okay, so let's imagine this scenario. The parties, meaning an applicant attorney and a defense attorney, they get together on the phone and they try to agree on an evaluator. And the applicant attorney may say, for example, do you agree to have Dr. Smith perform the evaluation? And the defense attorney may say something like, well, Dr. Smith, no way, he never does an accurate evaluation. How about we have Dr. Jones do the evaluation? I've used him before and he's always fair. And the applicant attorney might say something like, Dr. Jones, no way we're going to have Dr. Jones. He never writes a good report. And they cannot agree on an agreed medical evaluator. Well, once they could document to the administrative director that indeed they did attempt to agree, only then will the administrative director issue a panel, a 3-doctor panel of qualified medical evaluators. Well, it used to be that the parties then had to come together again, to try and agree on one of the doctors within the three-doctor panel. So let's say, for example, the three-doctor panel had Dr. Smith, Dr. Jones, and Dr. Williams. Well, the applicant attorney would call up the defense attorney and say, I see we have Dr. Smith, Dr. Jones, and Dr. Williams. Listen, would you agree to let Dr. Williams do this evaluation? And the defense attorney might say, Dr. Williams, yeah. I'm familiar with Dr. Williams. He always does a good job, and I'm okay. I'm comfortable with Dr. Williams. Yeah, let's go ahead and use Dr. Williams. Well, in that scenario, Dr. Williams became what was known at the time as the agreed panel qualified medical evaluator. And there were certain benefits ascribed to the agreed panel qualified medical evaluator, namely that the agreed panel qualified medical evaluator could bill at a higher rate, could bill at the same rate as the AME. And so that was an important distinction. Now, in those cases where the parties could not agree on an agreed panel qualified medical evaluator, they then went through the strike process, and the last man standing became known as the Panel QME, and we still have the existence of the Panel QME. However, we no longer have the existence of the agreed Panel QME because the process for selecting the medical evaluator has now changed. And in neither case do the parties have to be able to demonstrate that they've come together to try and agree on an evaluator, either before the issuance of the three-member panel or even after the issuance of the three-member panel. And I elaborate on this here extensively in this section because I received phone calls from doctors, less lately, but there was some confusion following the passage of Senate Bill 863, with some doctors confused as to the distinction between the agreed panel QME and the panel QME. And many doctors were under the mistaken notion that the last man standing after the strike process was the agreed panel QME. And they would ask me, well, I'm the last man standing. The applicant attorney struck Dr. Jones, the defense attorney struck Dr. Smith, and I'm Dr. Williams. I'm the last man standing. Aren't I the agreed panel QME? And the answer to that is no. No, you are not the agreed panel QME. Number one, nobody agreed on you. Nobody agreed to use you. You are the default last man standing that both parties seem to hate the least, apparently. You are not the agreed panel QME for that reason, that nobody agreed to use you. And then number two, that the designation of the agreed panel QME no longer exists because the process for agreeing on one of the three doctors of the three-doctor panel no longer is required and no longer exists. So now, by and large, and for the most part, we're seeing panel QME evaluations, and then in rare circumstances and much less frequently, we will be seeing occasional agreed medical evaluations in those situations that the parties decide to come together and have a common doctor, agree on a common doctor to provide comment on one or more of the issues in dispute. Okay? So that is the QME panel process. I think it's important that you understand some of the distinctions of the different types of evaluations that you'll be getting. You'll be getting compensability examinations. You'll be getting disputes over permanent disability. And then you'll be getting sort of the other category, the quote-unquote other category of disputes, all of which are resolved under Labor Code Section 4062. Now, what's changed regarding these three codes and the QME panel process since the passage of Senate Bill 863 is that qualified medical evaluators no longer resolve disputes over treatment issues. And that is a significant change compared to prior to 1/1/2014. We used to handle also disputes over medical treatment and the necessity and the type of medical treatment needed, but those issues are now resolved under the independent medical review process. Okay, so let's move on now to section 2 of this program and get into some of the issues related to the non-physical examination component of our face-to-face evaluation with the injured worker.